Something. Anyway, we'll make it work. We're going to get it done. We'll see what they have to say. Uh,
All rise. The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Yes, oh yes, oh yes. The Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good afternoon. The next case is State versus Williams, and we'll hear from the appellant. Good afternoon, Your Honors. May it please the court. My name is Michael Henry, Special Deputy Attorney General with the North Carolina Department of Justice. I authored the state's briefs in this matter and will be arguing on behalf of the state today. I would like to reserve 8 minutes for rebuttal. At the outset, I want to recognize just sort of how unusual it is to be making an argument that in part at least challenges some of this court's recent decisions. That's not typical and is quite uncomfortable, but it is extremely important for reasons I imagine we'll at least touch on as we go. That said, I do want to be clear up front that the state is arguing for 3 separate and independent avenues to correct the errors of the Court of Appeals. All of these avenues, either necessarily or by narrow understanding, can in fact avoid Phillips and Allison. They are, just to stick a flag in them before we move on to each of them, proper construction of the term occupant, which reveals the statute to be place-based rather than event-based. Proper construction of 14-51.2C5 exclusion, which surely does not require juries to resolve undisputed issues of fact. And an absence of prejudice, number 3, as there's no reasonable possibility of a different result had defendant received the instruction he requests. The first of these avenues doesn't touch Phillips and Allison at all. The second and third can be drawn broadly to engage them or not. Briefly then, just in terms of what the Court of Appeals got wrong. Both opinions below transform a narrow place-based statutory presumption into a portable event-based immunity. Then they insulate that holding from the trial court's traditional instructional gatekeeping authority, even when plainly not warranted by the evidence. They arrive at this result by failing to apply the geographic limits of the statutory text, which is to say they implicitly amend the statute to include a subclass of former occupants, limited only by extra-textual specific circumstances or direct continuation tests, and by ignoring undisputed facts in light of the plain language of the C5 inability provision, and then they compound these errors by presuming prejudice. So, with that in mind, we can turn to our first avenue, which is the construction of occupancy, the threshold requirement of the statute, which by its terms applies the presumption only to an occupant of 3 specific places during an active intrusion. And therefore, once an occupant, such as defendant, voluntarily exits these places, he is no longer an occupant. For purposes of the statute, the presumption no longer applies, and the trial court did not err.
Let me just stop you right there because you used the word in that, and I want to. So, you are conceding that if it was an involuntary exit,
sure,
then it would. So, for example, you know, if someone comes to you with a gun and you're in the curtilage of your home, they force you to step out onto the sidewalk as they're going to attempt to rob you. that you would still have the protection of the castle.
I think that pulls you directly into the removal against your will provision of the statute, and yes,
So then
at that point we're there. We're there.
I understood the Court of Appeals logic here to be that by extension, if someone's assaulting you and it's sort of a continual assault while you're in the vehicle, and the way that you can stop the punches and things like that is to, because it's much harder to sort of remove yourself from a situation like that in a car other than getting out of the car, that would be the same as the sort of involuntary exit from the curtilage of your home.
Right.
That was the theory they were relying on here.
Right.
So, and there's at least some testimony of that because there's the defendant's description of what was happening, right?
No. So that is just not a definition, or just not what removal against somebody's will means. The defendant's testimony testifies that he just felt too close to defend himself, so he got out, which is just a tactical exit. That is certainly not required. Nobody has a duty to retreat. You can choose to stay. If I'm in my kitchen and somebody busts in and they come to attack me, I'm clearly an occupant, I'm covered by the statute. I can make a decision about whether or not I'm going to have to defend myself either way. I can make a decision of whether or not I'm going to stand here in my kitchen and fight, or because my kitchen's too small, I don't feel like defending myself in my kitchen, my family's around, whatever reason, I want to run outside. And if the person follows me and we get in a fight in the street, the state's position would be that you weren't removed against your will. You made a tactical decision to exit, and now you're covered. You're still covered by defensive force law. It's just now it's a self-defense situation. You're no different than anybody else who was attacked in the street.
But I'm looking at the defendant's testimony, and he's asked, what is he doing while you're trying to get out of the car? And the defendant responds by saying, he is hitting me pretty much, back of the head, shoulders, back of the neck, because I had my back towards him as if I'm sitting like this. So, isn't that evidence that he's being struck even as he's trying to get out of the car?
Oh, of course he's being struck, sure.
So if the victim had pulled him out of the car, what would you say?
That would be totally different.
That's totally different.
Totally different. I think
he had the choice of sitting there and getting hit, or
no, he had the choice of defending himself there where he was, or exiting and defend himself elsewhere. I think in order for removal against the will to mean anything other than, well, I just decided to get out, which if it means that, this is a curious choice of language for the General Assembly. It has to designate something about the nature of the removal. It has to designate removal in general.
What if the victim had pushed him?
Mm-hmm. Yeah, then I think we would be much more close. Yeah,
because he was punching him.
There's no indication in the record from anybody that the reason the defendant exited, like we could say this two ways. There's no evidence that defendant the intruder sought to remove anybody. Martin didn't seek, there's no evidence anywhere, and from anybody's testimony, that Martin sought to remove somebody, that he made an effort to remove. He invaded to get at the defendant. Nor is there any evidence, so to put the other side of it, all evidence, I should say, so there's no evidence Martin sought to remove anyone. All evidence is the defendant elected to exit to better defend himself outside.
So you're saying, I just want to make sure I understand
definitely.
you. So you're saying we're looking at the intent of the aggressor, is that?
I think we're looking to see whether or not somebody was removed against their will. And I think the term, I think what that means can't mean, well, there was an intruder in my house and I thought I could defend myself better outside, so I left. I don't think that is a removal, nor is it a removal against your will. And that is how it operates. That is the operative thing that we're looking to achieve. And I think when there's no evidence that the intruder sought to remove anyone, and all evidence is that the occupant elected to get out to defend himself better elsewhere, there hasn't been a removal against someone's will. That's just not what removal against your will means. I think, and we can bolster that. So there are two statutory arguments made to expand this idea of an occupant, to say, well, an occupant really means is an event-based idea, and it applies to anybody, a former occupant, you know, in specific circumstances, or a former occupant just forever, or whatever. It is an event-based idea. There's two statutory provisions to support that. One is this removal provision, which I don't think does the legal work that the majority and the concurrence and the defendant wanted to do, for the reasons we've just discussed. And the within of distinction from the prior statute. And so, and we'll come back to that. But one thing I want to talk about, because, well, I think the within of distinction from the prior statute is easy enough to, it just simply captures, it is a result from the removal provision itself. So it just doubles back on the removal provision. So neither of these really do the legal work that the majority or the concurrence or the defendant want them to do. And I think on the other side of the scale, we can look back to the other statutory provisions within the statute itself. First of all, occupant itself doesn't mean former occupant. That's not the same thing. I think, so you have to implicitly amend the statute to get to where the Court of Appeals did. I think the statutory context of the statute, it applies to 3 identified places, and these are exclusive. Only one of them includes a curtilage. That, to me, is a double layer of emphasis on the idea that this is place-based. It covers these places. Only one of them has a curtilage, the other ones don't. I don't see how to read that as anything other than a boundary provision. The statute has a composite whole. The C5 exclusion that we'll talk about in a minute terminates the presumption upon a discontinuance of the efforts to enter. Enter where? The place. And exit. Exit where? The place. This again limits it to the place.
I would agree, for example, that if an assailant is out on the sidewalk beyond the curtilage of your home with a gun and begins firing into your home, and you fire back to protect yourself, that would be a Castle Doctrine case. Because the forcible entry is the bullets and things are flying into your home. I mean, wouldn't that be and isn't that what I understood the Court of Appeals reason here to be? The punches are flying into the car. The only way to avoid it is to get out. So this is not a situation where at any point, and if you believe the defendant's testimony, that was continued until forced out, and so that's why there's been no exit from the vehicle by the assailant.
I'm sorry, so what's the question?
So what I'm getting at is why can't we analogize it, as I was doing with other things, to a home and just say, so here, this is what's happening is the fists are still there. They were punching there in you.
The fists
forced
are
you out of but you wouldn't say because now the scuffle's been outside and it's nowhere near the car that the assailant has exited the.
Well, the fist didn't force
forcible entry.
Right? There's no testimony to that effect. The testimony is I was attacked in the car and I felt too close, so I got out, and then Martin got out and we fought there, and I shot him there. So this isn't a pushed out of the car. The fist pushed me out.
What if the victim had said while he was punching, "Get out of the car"?
At least now we have an effort where the assailant's trying to remove you.
So you would say in that case there's an attempt to.
I think you're going to be much closer. I mean, yeah, you have an assailant making an attempt to remove somebody.
Why couldn't a jury look at these facts and say that Martin was trying to force the defendant out of the car by punching him, and we can infer that in part because he didn't grab him and try to hold him in the car as he exited the vehicle?
There's just no evidence of that.
There's
You have a somebody comes into the car. He's clearly there to attack Martin. He's not trying to steal the car. I mean, we know what the background of this is, right? Martin is there to attack the defendant. He feels he's like a romantic rival, right? He goes into the car and he starts attacking him, and then in the defendant's testimony, Martin produces a gun even when he's in the car, points it at the defendant. Other testimony suggested it was the defendant's gun, but for self-defense purposes, we'll view it in the light most favorable to the defendant. He produces a gun. He never tries to get defendant out of the car. He's attacking the defendant. The defendant exits the car, then Martin exits the car and comes around and continues to do what? Attack the defendant. There is no evidence that he tried to force him out of the car. And that's part of the problem with the Court of Appeals analysis. There simply is no evidence that Martin attempted to remove anybody. All the evidence is that defendant elected to exit to better defend himself, which is fine. There's nothing wrong with that. But that means you are now no differently positioned than anyone else in the street when
What
somebody
if it's
attacks
not
you.
to
in the
better
street.
defend himself? It's just to get away from the assault.
That's not what the evidence is. The evidence is he felt too close to defend himself, so he exited.
But I mean, what I'm getting at is why isn't one of the reasonable inferences that there's a step in between there, which is, I need to, in order to defend myself, I need to not be sitting here where I'm getting punched and hit and I can't move and that sort of thing. So I've got to get out of the car. And if that's why you have to get out of the car, you can understand why perhaps the legislature wanted this to be a situation covered, just like being forced out of your home.
We are now, so in other words, just even though I don't testify, there is no evidence that I was pushed out. Somebody was just here and they were being violent towards me. And so I got out to defend myself somewhere else. And that just counts as a remove. Is that, I'm trying to understand.
I'm saying
that.
if there's testimony that someone is punching you in the backseat of the car, you've got to do something, and so you get out of the car and the person continues to assault you. All I'm saying is that there would at least be enough, if that was the testimony of the defendant, that would be enough for the reasonable inferences that would get you the instruction. And what the state would do is say, I need a special instruction then for the jury to work this out and figure out what actually happened. And if you don't believe that was the reason the defendant got out of the car, you skip Castle Doctrine and you go straight to traditional self-defense. But if you think and just do it, and that's how we make this work. Otherwise, we've got the problem we keep having in all these cases, which is these trial judges just aren't giving the Castle Doctrine instruction. I think because they're convinced if I give it, this defendant is going to be acquitted.
I think that's just not what removal is. I think removal against the will isn't that. I think that rewrites the statute to say if you just decided that it would be better for you to get out, that's enough, which is just not what the statute says. I think in terms of I'm afraid if I give the statute, the defendant's going to be acquitted. I don't think that has any traction here from a prejudice standpoint, which is what the essential thrust of that is. I mean, I don't think there's any reason to conclude the defendant was an occupant. He exited the car. And I think it's undisputed that Martin was not seeking to enter, and he exited, which therefore invokes C5 as well. So I think there's basically zero chance in order for a defendant to show a reasonable possibility of a different result on a prejudice analysis, the jury would have to find in favor it would have to find in favor of elements for which there is no evidence. It would be a verdict that'd be unsupported by the evidence, because it's undisputed that Martin had discontinued his efforts to enter and exited, and it's undisputed that the defendant wasn't an occupant anymore. So there's no way to get to prejudice in this case, nor would there be any reason for the trial court to think that the jury would acquit him under this rubric. I mean, just to address that specific case, I don't know if generally speaking trial courts aren't giving this because of a fear of acquittal, but here I don't think that is plausible at all. I think what the trial court said at the charge conference, which is that there was no occupants, is exactly the result that he would have expected the jury to arrive at. So I think, I mean, on the removal provision, again, I just don't think, I think saying removal against your will means I feel like I could defend myself better somewhere else, therefore I'm going to leave, and this just comes with me, is just to rewrite what removal against the will means. I don't think, on the occupant language itself, I don't see how defendant could possibly still be anything other than a former occupant. The statute contemplates discrete, distinct, identified places, and it is a present tense idea of an occupant. The common law itself, from a common law continuity standpoint, was clearly circumscribed sharply to the idea of the physical location. It applied literally to the boundaries of the home. And the minute the defense wasn't about that, it became a global self-defense theory, or the defense of others, or self-defense, or whatever. Which is to say that...
Not to beat a dead horse, but on this removal question, if the defendant had testified slightly differently, if he had said, I was getting punched in the head, I didn't make a tactical decision to leave. Like, I was getting punched in the head, I couldn't think straight. would that then sort of get us closer to removal because it wasn't a decision he made? He was being punched in the head and couldn't think straight?
No, I don't think that would do it either.
So,
Go.
I'm sorry, I didn't mean to interrupt your answer.
No, no. Yeah, I don't think that would do it either. I wasn't sure how far you're going to change the hypothetical. I do think eventually you get there. I think if Martin, to go to, I think it was your Honor's question, where you're saying if he was punching him and Martin was saying, get out, I'm going to take you out here in the street and beat you up or whatever, and he's pushing and shoving and punching him, or he comes around the window and tries to drag him out. Now we have a removal or an attempt to remove. That's what the statute says, an attempted removal against the will of the occupant. That is different than if you come in and invade and attack, and the occupant themselves just say, I don't want to defend myself here, I'm going to go somewhere else. And again, there's this sort of underlying current of like, we're really depriving the occupant of something. But we do need to remember that at that point, once an occupant says, I'm going to leave, I don't want to be here anymore, I'm going to defend myself out in the street instead, they literally are no differently positioned than anyone else who is attacked in the street, who is protected by the self-defense doctrines that we all are protected by, and that I would be protected by on the way home or on the way back to the office today if I'm attacked in the street. It's just you're not in the home anymore, and you haven't been forcibly removed.
So my question is, I'm trying to understand, it seems like you're trying to draw a distinction between being forced out and being removed. And that those I don't, help me understand the distinction there.
Yeah, I think I'm just collapsing the against the will into the removal thing.
Right, so
go ahead.
So isn't it, if here the facts in the light most favorable to the defendant, a jury could find that he was being forced out of the car because of how he was being beaten, why isn't that in essence being removed?
Because he wasn't being forced out of the car, in the light most favorable to the defendant or otherwise. He was being attacked. He was being punched in the car, and then he reached outside the car,
Right.
said he was too close to defend himself, and opened the door handle.
Being
and
forced in the sense that in his judgment, the only way he could escape and stop the beating was to get out of the car.
I think at that point, if we're going to reduce what removed against the will means to the point that it simply just means I don't like being here anymore, and I'm being attacked here, and I just don't want this occurring. So I am going to get out, and which is what the evidence is. And I'm going to get out, and then we're going to keep fighting in the street. If that is what removal against the will means, then I don't think that language has any limiting function at all. I mean, every case that will involve this statute is going to involve an intruder. And if that's enough to get us to removal against the will, then I think
But you can imagine scenarios, I think, that even if we regard this as a removal, that would be similar, but clearly wouldn't lead to the same result or entitle a defendant to an instruction. I mean, suppose that Martin here had punched the defendant one time, and then there had been some lapse of time, and maybe they'd exchanged words, and then the defendant had gotten out of the vehicle. We wouldn't say that's a removal. So it's not a. So I don't think what we're talking about is a limitless rule.
I mean, I think it would be limitless in the sense that if we have an attack, it is a removal. An attack that's existing, not in your Honor's hypothetical. It's punch him one time and then they exchange words and they whatever. Then the attack is sort of over, right? We're not physically attacking. There's an intrusion, but there's no physical attack. I think that to the extent we're just going to say, well, if there's a physical attack and it's happening, and the person says, this is going on, I feel like I'm going to defend myself better somewhere else, and they exit, that's a removal against the will. I just think that rewrites what removal against the will means. And I think that gets to another criticism of the Court of Appeals argument in the state's brief, which is that it makes it really amorphous and arbitrary. It again creates an event-based presumption, which is not how the common law operated, and the statute clearly doesn't provide any sort of express direction in this regard. And it's meant to be a codification of the common law. So, and the common law itself clearly circumscribed the boundary tightly at the boundary of the home. The statute doesn't suggest otherwise, unless we sort of rewrite what removal means and sort of take these maneuvers. And I think any event-based construction like this, a consequence of it becomes that the occupant status and therefore the presumption follows indefinitely unless we have some kind of limitation, which is why the Court of Appeals inserted its specific circumstances test or direct continuation test. Defendant has no test. It just continues until one of the sections, subsection C applies, which in this case the state would say subsection C5 applies. But short of that, it would just continue indefinitely until that occurs. That's not how the common law defensive habitation operated, which this statute is supposed to codify. And there really is just nothing in the statute to provide that. The defendant is never deprived of the ability to defend himself. He comes out and he's subject to other global self-defense theories. I am gobbling up my time. I think C5 we've talked about. I just don't, there just is no evidence that Martin had not discontinued his effort to enter. It doesn't really matter how the fight happened out. Saying, the concurrence's direct continuation test, for example, or the majority's specific circumstances test, to create ambiguity or dispute around C5, just rewrite C5, right? There's an effort to enter and an exit. Continuing the fight outside is neither an effort to enter nor a reversal of an exit, right? I mean, C5, it is just undisputed. In order to dispute that, we need to say that those words don't mean what they mean. They mean something else. Prejudice analysis, I think at a minimum, these very same arguments that the state is raising to dispute occupant status and to dispute and to explain why defendant was not an occupant and to explain why Martin had exited or had discontinued his efforts to enter and exited, those same facts illustrate that the jury, there is no reasonable possibility that the jury would have found that this, even if the defendant received his instruction, would have applied. We talked about the removal against the will and the related within of distinction. I am going to take the remaining 4.5 minutes for rebuttal.
Thank you, counsel. We'll hear from the appellee.
Good afternoon. May it please the court, I am Narendra Ghosh, and I represent the defendant, Mr. Alan Williams. The issue in this case is whether the trial court erred in failing to instruct the jury on the statutory castle doctrine defense. As all three judges on the Court of Appeals panel agreed, the trial court's decision was erroneous and prejudicial. On the evening of August 1st, 2020, Mr. Williams had met up with Miracle Lewis for a first date. They were sitting in Williams' car right outside Miracle's house. Unexpectedly, Miracle's ex-boyfriend, Martin Penny, pulled up to the house in a truck along with his brother. Miracle described her ex-boyfriend as jealous and aggressive when intoxicated, and Penny had been drinking. According to Williams, as soon as Penny got to the car, Penny opened the passenger door and asked Miracle, "Who the F is this?" When she didn't respond, Penny asked Williams, "Who the F are you?" Before Williams could answer, Penny started punching him in the face while leaning into the car through the passenger side door. When Penny brandished a gun, Williams was able to wrestle it away from him. This is exactly the type of situation the Castle Doctrine statute is supposed to cover. Penny had forcibly and violently entered Williams' car while Williams was inside in order to assault him. Williams had the right to defend himself, including with deadly force. If Williams had used deadly force to protect himself at this point, there's no question the Castle Doctrine statute would have applied. However, Williams didn't use the gun right away. Instead, he tried to get away from Penny. And there were several questions about what Mr. Williams was trying to do when he got out of the car, and I would like to point the court to some of the record here. If you look at page 863 in the transcript, and this is during the cross-examination by the prosecutor of Mr. Williams, they're talking about the point after which Mr. Williams had gotten the gun. At the top of page 863, the prosecutor asks, well, at that point, why didn't you just take the gun and shoot him? And Mr. Williams answered, I wasn't trying to hurt him. I just didn't want to be hurt. Right? That's why he was getting out of the car, because he didn't want to be hurt. He is trying to escape from the blows that Penny is inflicting upon him. And you see this repeatedly in the record, such as at pages 856 and 857, when he's describing the course of events when he's being punched by Penny. He says repeatedly, most of my focus is trying to get out of the car. Or another on 857, I'm focused on getting out of the car. I leaned toward my driver's side door and started trying to get out of the car. Of course, he was having trouble getting out because his door handle was broken, and it took some maneuvering to get outside and open it properly. So the evidence is that he was trying to get out of the car because he didn't want to get hurt, because he was trying to escape the punching and the blows that were being inflicted on him. Opposing counsel repeatedly refers to the phrase that Mr. Williams said he was too close, as sort of inferring that Mr. Williams wanted to fight back and it was too close, and so he wanted to fight back outside. And I don't think that's what the record shows. Again, his own testimony about his intent was he was trying to stop from being hurt. That's why he was getting out. The phrase too close comes from, it's page 858 in the record. The prosecutor asks him, so for 30 seconds, you're getting punched on and you don't push him away or look at him and shove him in the face because he's close to get some distance between the two of you. So he's asking, like, why aren't you fighting back? And the answer is no. I was too close and trying to get out of the car at the time. So again, when asked why he is not fighting back, I'm trying to get out of the car. And when on page 863, when just why didn't you shoot him, is I'm not trying to hurt him. I'm trying to stop from being hurt. So he was trying to get away from Penny. He opened his car door and stepped right outside. Penny could have abandoned his attack at this point, either going back to Miracle's house or going back to his truck, but he didn't. He came around to the driver's side of the car and continued assaulting Williams. After taking his blows, Williams used his gun and shot Penny. The state first maintains that the Castle Doctrine statute doesn't apply because Williams was outside his car when he shot Penny. The state's position is wrong. It's a straightforward matter of statutory interpretation. I agree with the state that in this context, the word occupant means someone physically inside a motor vehicle. Our difference is the point in time in which the person needs to be inside the vehicle. The crux of the Castle Doctrine statute is that an occupant can respond to an unlawful and forcible entry of his vehicle with defensive force. So as Judge Stroud concluded, the plain reading of the statute is that an occupant of a motor vehicle is someone inside the vehicle at the time of the unlawful and forcible entry. In the recent Allison decision, this court embraced this interpretation as well, laying out the proper jury instructions for the Castle Doctrine statute. The court specified that the initial instruction should ask, quote, ask the jury whether the intruder had unlawfully and by force entered or attempted to enter the protected location, and whether the defendant was a lawful occupant of such location at the time of the unlawful entry. That's Allison at page 494. So just like Judge Stroud's definition, this court focused on physical occupancy at the time of the unlawful entry.
So suppose in this case that when your client exited the vehicle, suppose he took off running, and then suppose that Martin took off after him, but didn't catch him until he was roughly a quarter mile from the vehicle. Would your client still be entitled to a Castle Doctrine instruction?
I think that would implicate the C5 exception, because what limits ultimately the applicability of the presumption is whether the intruder has exited and discontinued all efforts to enter the protected location. And certainly if they've run a quarter of a mile away from the car, there's a very good argument that the intruder, Penny, has given up trying to get into the car. So I think that provides a limiting boundary there on the presumption's applicability.
And going back to my question earlier, because we keep encountering this in these Castle Doctrine cases, is the state could request that the court give a particular sequence of instructions. I think we talked about it in one of the cases a year or so ago. It's almost like, like you're programming a computer where you tell the jury, now, at step one, you make this determination. If it's this, you skip over this and you go to this. And I understand that it's complex, but we trust juries to hear these instructions and follow the law. And so that would address the state's concern about giving what's a very powerful protection, because you could make sure the jury understood, but you're only going through this if you've satisfied a series of other things. And if not, you go down to traditional self-defense. And it seems to me that would be the way to avoid the risk of a jury getting confused about, using the Castle Doctrine when it shouldn't or anything like that.
Yes, I agree, Your Honor. And I believe this court recently has attempted to provide exactly that sort of guidance to how that should be done. So in the recent Allison decision, this court walked through kind of what are the instructions to be given. Not all of them, but what are the initial instructions? Again, was there forcible entry? Was the person an occupant at the time of the entry? And then goes through. You can then give the instructions on exceptions if the state has put forward some evidence to support the exception. And then if there is some evidence to support the exception, then you give give an instruction on the exception. And then you explain that if the jury finds the exception has been proved beyond a reasonable doubt, then the presumption is rebutted, and then you return to the world of self-defense without the presumption. So obviously, this trial occurred in 2023. Doesn't have the benefit of this court's more recent jurisprudence, but I think what this court has been laying out in its recent cases provides that sort of step-by-step framework for juries to answer these questions, and also do it in a way so that they are not applying the presumption in situations where it's not intended to be applied.
And Counselor, you mentioned, and I agree with you, that part of the Judge Stroud concurrence opinion focused on where the person was when the attack occurred. But I was also, the way I read it, she had a second part to that, and it was the direct continuation of the brawl, or whatever we want to call it. Do you agree with that, or do you have a different way of looking at that?
I do, I guess, in terms of how to read her concurring opinion. She does seem to say slightly different things at slightly different points in the opinion.
And I quote, she does say that it was a direct continuation. And I have concerns that I don't want to just blow this thing open so that anytime something starts in a car, it can carry on, very much like I think Justice Allen was alluding to in his hypothetical. But I was intrigued by her analysis about direct continuation. And so you may agree with my reading, but do you agree philosophically? Is that your position in this, or is there something else we should be looking at?
My view is that that's not necessary to, I think, a straightforward definition of occupant, which is just someone inside the car at the time of the unlawful entry, is both faithful textually and also just makes sense because it grounds the analysis in the concern of the statute, which is giving someone the ability to respond to a forcible intrusion. I think the idea of maybe what was animating Judge Stroud with the idea of a direct continuation is, again, to try to have some sort cabining of when use of force can happen outside a vehicle, I think the statute already provides that with the C5 exception, as I sort of indicated in my answer to Justice Allen's question. So if someone was inside the vehicle and, if the C5 exception has not been met, that means that the intruder is still trying to get into the vehicle or get into your house, right? So if the C5 exception has not been met, the attempted intrusion is still happening. And so in those situations, the presumption should apply. Here, because Williams was inside his own car when Penny began his forceful entry and attack, he was an occupant under the statute. And the statute does not require an occupant to be inside his vehicle when using force that is presumed reasonable. And based on the text, we know that for two reasons. First, the operative language of 14-51.2b provides the presumption of reasonable fear to the lawful occupant of a home, motor vehicle, or workplace, rather than an occupant within one of those locations. And the history in the statute and the broader text shows this distinction was intentional. Under the common law, the Castle Doctrine only applied within a home. And when the Castle Doctrine was first codified in 1994, the statutory defense of habitation justified the use of force by, quote, a lawful occupant within a home or other place of residence. And that's the old statute 14-51.1. So again, when it was under the prior regime, statutory regime, you had to be within the home when using force. But when the General Assembly enacted the current statute, it used the term within in a different part, but not in 2b. So in subsection F, a lawful occupant within a home has no duty to retreat. But in subsection B, when we're talking about the presumption, it says the lawful occupant of a home, motor vehicle, or workplace. The text is occupant of instead of occupant within. And that intentional distinction means the use of force does not have to occur inside the home or vehicle. Second, the other way we know this is that the full scope of the Castle Doctrine presumption shows it can apply to the use of force outside the home or motor vehicle. Under subsection B1, the presumption applies where the intruder, quote, had removed another person against their will from the protected location. So if force is permitted when an intruder had already removed an occupant from the motor vehicle, that means the occupant can use force when outside. So if someone is inside the vehicle at the time of the unlawful and forcible entry, they are an occupant entitled to the Castle Doctrine presumption, regardless if they are then inside or outside when using force, as long as the state does not prove one of the statutory exceptions. Now, I want to get to the exception that's most germane here, which is the C5 exception. Under that exception, the presumption does not apply if the attacker has exited the protected location and has discontinued all efforts to enter the location. And as this court has made clear, the jury has to find the exception has been proved by the state beyond a reasonable doubt. It cannot be decided in the first instance here on appeal. The state repeatedly says the evidence is undisputed, but the state is wrong. There is certainly evidence that Penny had not discontinued all efforts to enter Williams' car. After Williams was able to get out of his car, Penny got out of the passenger's side of the car, went around the front, met Williams on the driver's side, and rushed at him. Penny never paused his attack. Penny did not move away from the car. Penny did not flee back to his truck or to the house. Penny did not say he was leaving. Based on Penny's conduct, if Williams had then stepped back into his car, it's likely Penny would have tried to breach the car again. This means he had not discontinued all efforts to enter the car. Given this evidentiary record, a jury could easily decide the state has not proven this exception beyond a reasonable doubt. And that's all that's required here. And the point of the exception is to provide, it does provide a very important limiting principle. Because you have the exception, there's no license to use force against an attacker who has called off the attack and is fleeing the premises. If the attacker comes into a home, sees the homeowner is armed, leaves the home and runs away, the homeowner can't shoot him in the back as he flees. But that's nothing like what happened here. And as this court has said, the jury must intentionally and methodically determine whether the presumption has been rebutted. This is Allison at 493. And at 494, it makes clear that the state has to prove the exception beyond a reasonable doubt. Given the evidence here, this determination cannot be made by the trial court and certainly cannot be made by a court on appeal. Instead, in a new trial, the jury will be properly instructed per Allison and then make this determination in the first instance.
So it seems to me like you're arguing that we can take from the fact that the victim continued to attack defendant, that somehow equals a continued effort to forcefully enter the vehicle. I'm having a little trouble with that.
Well, again, I think it's again, what has to be proved by the state is that Penny had discontinued all efforts to get into the vehicle. He had completely given up on getting into the vehicle. And in a situation where it's, again, basically one continuous attack, he punches him in the car, then they get out, and he runs around to the side and keeps going at him, I don't think it's fair to infer that he has not given up all attempts to get into the vehicle. And certainly if Williams had then himself managed to get back in the vehicle, Penny would have gone after him. I think a jury could reasonably infer that. And certainly when it's the state's burden to prove the exception beyond a reasonable doubt, I think that's the question. Then there just has to be enough evidence that the jury could have a reasonable doubt of his intent to discontinue. And I think given the course of events here, there is certainly enough to say that. A couple of other points that came up with the state's argument. There was much discussion about whether or not Williams was removed from his vehicle. Two points on that. First, removal is not necessary for him to get the entitlement to the presumption under subsection B. Removal is one prong, but it can also be someone is in the process of unlawfully entering, or someone had unlawfully and forcibly entered. And in this case, certainly, Penny had unlawfully and forcibly entered. So just under that prong, he satisfies subsection B, regardless of whether or not he's removed. Now, certainly defendant's position is that the actions here qualify as a removal. When Penny is punching him and he's trying to get out, and then he just keeps punching him some more until he gets out, I think it is fair to infer that he intended his removal from the vehicle. Certainly a jury could make that inference, and so certainly whether or not there was removal is a question for the jury. Another point that the state raised is that if an occupant of the car can use force outside the car, that would contravene the common law. And that is true, but that's because the common law no longer controls. The statute here did not merely codify the common law, it greatly changed the common law. And this court has said in Phillips, it is the statute that controls. I think Justice Deeth said in his concurrence in the Hicks case, quote, when addressing self-defense under these statutes, there is no common law. There's only the language of the statute. And so defendant's position here is based on the language of the statute, interpreted by looking at the full text. Finally, on the question of prejudice, here what happened at the original trial is that Mr. Williams was acquitted of first and second degree murder, but found guilty of voluntary manslaughter because he used excessive force. So if the jury had been instructed on the Castle Doctrine statute properly, it is very likely, and certainly a reasonable possibility, that it would have credited that defense and found Williams covered by the presumption. And as this court said in Phillips and just reaffirmed in Allison, excessive force is impossible when the Castle Doctrine presumption applies. So if the jury had found Williams covered by the presumption, it would have to find him not guilty. The state argues in its brief against prejudice by saying Phillips and Allison were wrongly decided on this point. They were not. They control here. And based on Phillips and Allison, prejudice is clear. Unless the court has any other questions, I'll conclude by asking that the Court of Appeals decision be affirmed and that this case be remanded for a new trial. Thank you.
Thank you, counsel. Rebuttal.
Okay. First, I think I'll make a quick point up front and then respond to as many of those as I possibly can. One is the state obviously seeks reconsideration, Phillips and Allison, for arguments that are laid out in the brief. The Phillips, in particular, didn't address the arguments that are raised in the state's brief because they weren't raised in Phillips. And I think Phillips makes at least two substantial moves that the statute absolutely does not make. First, it takes evidentiary assumptions, occupant fear and intruder intent, and equates them to legal conclusions, which would be the presumption of justified deadly force. The statute just does not do that. That cannot be the right solution to that ambiguity. It turns the content of those presumptions into surplusage, and it eliminates excessive force without an express statutory directive to do so, despite the fact that it is a codification of the common law itself. And the second basis being the shall be rebuttable issue. The state does encourage and request that if the court considers or uses Phillips and Allison to resolve this case, it address those arguments.
I'm sorry, counsel, that if I recall correctly, your brief cites to the state's previous argument in Allison. It does not cite to Allison because I don't believe Allison had been decided.
Correct.
Why doesn't Allison address what you just mentioned?
In Allison, I took over at the oral argument stage in Allison. So when I came in Allison and argued that case, I mentioned some of these arguments that are raised in that brief, or in the briefing in this case. None of them were addressed in Allison. I assume the court just didn't seek to find them worthy of discussion, or maybe because they hadn't been developed in the briefing. I'm not sure. But they still, whether in the Allison opinion or the Phillips opinion, neither opinion addresses those arguments. On rebuttal, I think, I mean, the essence here of what we're looking at is that the statute is being said to say a lot of things that it just doesn't say. You know, I think Justice Allen's point about running off for a quarter mile is a great point, and the idea that C5 would then come in and would somehow resolve that. I mean, C5 would do the same function here. There's something very strange about requiring, in terms of a jury sequencing argument, for example, of requiring the jury to assess undisputed facts. I mean, when we have, in this case, all of the testimony the defendant read is all about the defendant seeking to exit, the defendant making the choice that it would be better to defend himself outside. He was not removed. I think we run into the problem of if it is about, well, Penny had entered and therefore occupant applies endlessly, that runs into all the same problems that we've already discussed. This is a place-based limitation. That is how the common law conceived of defensive habitation. Nothing in the statute defeats the idea that this is a place-based limitation. The defendant is not deprived of any rights to defend himself anywhere in the world, and it certainly shouldn't be, the statute certainly doesn't apply, nor should it be construed as to allow occupants to sort of just run out to any distance that is convenient for the defendant. So just 2 points in closing. This case is about statutory sequencing. The 14-51.2 presumption cannot apply unless defendant was an occupant and unless subsection C5 does not bar it. Both of those conditions fail here. That is the end of the case. Defendant was entitled to self-defense instructions, and he got them. Second, even if the presumption should have been given, prejudice is not presumed. Given that defendant was not an occupant, he got out, and given that Martin had discontinued his efforts to enter and exited, there is no reasonable possibility that the jury would have found contrary to that evidence and acquitted defendant under the same instructions. That similarly ends the case. So the Court of Appeals has expanded a place-based presumption far beyond that into a portable event-based immunity. That is not something that is provided for by the statute. And therefore, the Court of Appeals should be reversed. Thank you, Your Honor, very much.
Thank you, counsel.